You will pay these dues or the police will be involved.
That's what the HOA president yelled at me through my own front gate, while a Beaufort County deputy stood 3 feet behind her, with one hand on his cruiser and the other on his Stetson. The dues were $4,800 she had invented as adjacent landowner community fees. I was not, and had never been, a member of her HOA. My family had been the landlord of her entire community under a 1987 ground lease for $54,000 a year. The HOA had been in default on it for 11 months. Margot Seeley didn't know I'd spent 32 years as a real estate attorney specializing in ground leases. She didn't know the reversion clause she'd ignored had triggered 6 months earlier, so I didn't argue with the deputy. By sundown, I owned the streets she drove on. Tell me below, would you have paid or filed the deed? The Caraway place sits on the high ground of a tidal bluff at the north end of Battery Creek in Upper Beaufort County, South Carolina, 22 miles from the bridge to Hilton Head and 40 minutes from the federal courthouse in Charleston. 220 acres, live oaks, Spanish moss, a salt marsh that runs to the May River on the far side of a tract of cordgrass my great-grandfather called the lower bottom. The house sits on the same brick footprint my grandfather laid in 1922. The dock is the third one in the same spot since Reconstruction. My great-grandfather Roderick Caraway bought this parcel in 1879 from a cotton broker named Pinckney, who'd lost everything but his hat in the war. The deed has been in the family ever since. I'm Easton Caraway. I spent 32 years at a Charleston law firm called Hayward, Quintrell, and Pelham, specializing in commercial real estate, specifically structured long-term ground leases, the kind of agreements where one family owns the land under a building or a development, and another company owns the improvements on top of it. The kind of agreements where the lease runs 50 or 99 years, and every paragraph is a small machine designed to handle a future the original signers will never see. I made partner in 1998. I retired in 2022. I've been divorced since 2004, amicable. My ex-wife is a watercolorist who lives in Mount Pleasant and sends me a Christmas card every year. We never had children. My terrier Sissy and I share the house with my mother, Lavinia Caraway, who is 89 years old, was a Beaufort High School English teacher for 41 years, and could still diagram a sentence faster than anyone I have ever met. My older sister Beulah Caraway Pinckney lives 20 minutes north in Port Royal. She was the Beaufort County Clerk of Court for 30 years before she retired in 2021. She knows where every deed in this county lives, and who signed it, and which clerk wrote it down. She is the reason I always knew the records. In the spring of 1987, my father, Pinckney Caraway, leased 60 acres of the family tract to a developer named Hollister Marsh Wren Development, LLC. The lease was a 50-year ground lease. The annual rent was set at $54,000, adjusted for CPI. The lessee was permitted to build a residential community on the leased acreage, with all improvements reverting to the Caraway family at lease termination or upon material default. The developer built 138 homes between 1988 and 1992. He called the development Marsh Wren Point. Brick fronts, white columns, live oaks, a clubhouse, a community dock that I could see from my own porch through Daddy's old field glasses on a clear day. For 31 years, the lease ran clean. The HOA paid the rent on the 1st of every June. My father deposited the checks. After he passed in 2008, the checks came to me. In 2018, the Marsh Wren Point HOA elected a new president, Margot Seeley, 47 years old at the time, petite, blonde, with a degree in interior design from a small college outside Atlanta, and a husband, Thatcher Seeley, who ran a real estate brokerage out of Bluffton. She introduced herself to me by way of a polite letter suggesting we modernize the ground lease arrangement. I wrote her a polite letter back declining. The letters got less polite over time. In June of 2024, the HOA's rent check arrived $400 short. Margot's note said the difference was a lease administration adjustment the board had voted in. I wrote her back, citing paragraph 11 of the lease, which gave the HOA no such authority. In July, the check arrived $900 short. In August, it didn't arrive at all. In October, an invoice arrived from the Marsh Wren Point HOA, addressed to me. It demanded I pay $4,800 in adjacent landowner community maintenance dues. I did not pay it. That was the first letter Margot Seeley ever wrote me, that I taped to the inside of my legal pad without responding. It would not be the last. I called Margot Seeley on a Tuesday morning, 2 weeks after the invoice arrived. She picked up on the second ring. She was at the HOA office. I could hear the chlorine from the community pool through her window. "Mr. Caraway, I was wondering when you'd reach out." "Mrs. Seeley, I'm holding an invoice from your HOA. It's addressed to me. It's for $4,800. I'd like you to explain it." "Of course. Our board voted in August to extend community standards enforcement to all adjacent landowners whose properties materially affect the visual and operational character of the development. Your 220-acre tract abuts our community along 900 linear feet of the eastern boundary. The board determined that this constitutes adjacent participation and that proportional dues are owed." There was a small silence on my end. I had been a lawyer for 32 years. I had seen creative billing. I had not seen anything quite as creative as a homeowner association inventing a category of dues payer to charge a non-member based on the proximity of his oyster pond. "Mrs. Seeley, I am not a member of your HOA. I do not own a lot within your development. I am the landlord of your entire community under the ground lease your developer executed with my father in 1987. I do not pay dues to my own tenant." "Mr. Caraway, the board has consulted with counsel. We're confident in our position. And frankly, the lease itself has been a matter of some informal review on our part." "What kind of review?" "Just due diligence, making sure everyone's understanding of the obligations is current." I told her the invoice would be returned uncashed. I told her I would not be paying dues to my own tenant. I told her the rent payments she had been short paying since June were now $1,100 in arrears, and that I would expect them brought current within 30 days. She told me she would discuss the matter with her board. She hung up. I stood at the kitchen window for a long moment. My mother sat at the table with the New York Times Sunday crossword from 2 weeks before. Sissy sat at her feet. The salt marsh ran out toward the May River in long ribbons of cordgrass that hummed in the morning wind. My mother did not look up. She said, "Easton, that woman wants something she has no right to." I told her I knew. She filled in 3 across without looking at the page. The first sheriff's deputy came to my front gate 3 weeks later. His name was Ainsley Trippett, 26, reddish hair, polite to a fault. He stood at my gate at 4:30 in the afternoon, holding a citation pad and a polite request. "Mr. Caraway, I got a community concern call from Marsh Wren Point HOA. They've reported that you're in non-compliance with community standards and have been harassing the HOA board with refusal to pay correspondence." I asked him to come up to the porch. I poured him a glass of sweet tea. I sat him down. I pulled 3 things out of my desk. The first was a certified copy of the 1987 ground lease, bound in green binder tape, 62 pages thick. I opened it to paragraph 11 and let him read the clause that explicitly forbid the lessee, Marsh Wren Point HOA, from imposing any obligation on the lessor, the Caraway family. The second was the HOA's invoice, demanding I pay them $4,800 in adjacent landowner dues. The third was a printout of the HOA's rent payment history, showing 11 months of partial or missing payments, totaling $46,500 in arrears against my family. Deputy Trippett read all 3. He set them down. He looked at me. He looked at the sweet tea. He looked at my mother, who had wandered out onto the porch with her crossword. "Mr. Caraway, with respect, the HOA dispatcher told me you were an aggressive resident refusing to pay your dues." "I'm not a resident, Deputy." "I see that now." He stood up. He thanked my mother for the tea. He walked back to his cruiser. He drove away. That evening, the Beaufort County Sheriff's Office filed an internal report classifying the call as civil matter, no police merit. The next morning, Margot Seeley filed a complaint against Deputy Trippett, with the sheriff alleging he had been rude and dismissive during the call. The sheriff filed the complaint in his desk drawer. He had been the sheriff for 14 years and had run against my sister for the Democratic nomination for clerk of court in 1992. He had lost. They had stayed friendly. He had a long memory for the kind of people who tried to weaponize his deputies. He did not return Margot's call. Margot Seeley spent the next 6 weeks running a slow, organized campaign of pressure. She filed a quiet title action in Beaufort County Court of Common Pleas. The complaint alleged that the original 1987 ground lease had been invalidly executed due to a missing notary acknowledgement on page 43, and that the Marsh Wren Point HOA's continuous occupation of the property since 1988 had created an adverse possession ripening into fee simple ownership. South Carolina adverse possession requires 10 years of open, notorious, hostile, and continuous use, and explicitly excludes lessees who have been paying rent under a lease. The HOA had been paying rent for 36 years. The complaint had no legal merit. She filed it anyway. She wanted to muddy the deed. She also went to her husband Thatcher's golfing partner, who happened to sit on the Beaufort County Council, and asked him to introduce a resolution invoking the county's Title VI, Chapter 7 powers, a rarely used set of statutes intended for tax default takings, to declare the Caraway parcel's eastern boundary a matter of regional development concern. The county councilman who introduced the resolution had not read it. My sister Beulah called me on a Thursday afternoon from her gardening shed in Port Royal. She had her old Beaufort County Clerk of Court badge framed on the wall behind her. She had known about the resolution by Wednesday morning because 3 former colleagues had called her by lunch. "Easton, there's a Title VI resolution being introduced at next month's council meeting. They're trying to mess with your eastern boundary." "I know." Effie Maitland called me from the records office. She said Margot's husband has been at the deeds office every Friday afternoon for 2 months, pulling files. Looking at what? Looking at the Caraway tract, pulling everything from the 1879 acquisition forward, particularly anything to do with the 1987 lease. What do you think he's doing? He's trying to find a flaw in the chain of title. He's trying to find anything that would let him challenge your ownership or invalidate the lease. I sat at my desk for a long moment. I asked Beulah to come over the following weekend with whatever she could pull discreetly. She did. She brought a banker's box and a thermos. She brought every recorded document associated with the Caraway parcel from 1879 forward. Every signature card, every notary stamp, every transfer, every tax assessment, every property survey, every easement filing. We spent 10 hours at my dining room table. We found exactly nothing wrong with the chain of title. We did find something interesting in the lease itself. Paragraph 31 of the 1987 ground lease, the reversion clause, was the kind of paragraph that lawyers write to handle situations they're certain will never occur. It read, in full, if the lessee fails to remit any portion of the annual rent for a period of 12 consecutive months, the lease shall terminate immediately upon written election by the lessor, and all permanent improvements located on the leased premises, including but not limited to roadways, common structures, gates, walls, recreational facilities, and any other real property classified as common area under the Marsh-Wren Point Declaration of Covenants, shall revert to the lessor at no compensation, free of any encumbrance held by the lessee or its assignees. It did not include the individual residential lots, which the lease had explicitly carved out as separately deeded fee-simple parcels owned by the homeowners. It did include every other inch of the Marsh-Wren Point development: the roads, the clubhouse, the pool, the community dock, the gatehouse, the undeveloped common acreage along the marsh, roughly 43 acres of common area. Beulah looked at me across the table at 1 in the morning. The kitchen smelled like Earl Grey and printer toner. "Easton, when did the HOA stop paying?" "August of 2024. "And what's today's date?" I looked at my phone. "October 17th of 2025. She set her tea down. 14 months. 14 consecutive months of non-payment. The reversion clause activated automatically in August of 2025, 2 months ago. I sat back in my chair. I did not say anything for a long time. Beulah said one sentence. "Easton, they've been calling the cops on the man who owns the land under their feet for 2 months, and they don't know it yet." She poured herself another cup of tea. I started writing a list. The Marsh-Wren Point HOA newsletter for November led with a 4-paragraph piece titled, "Adjacent Boundary Concerns, a Note from Your Board." It did not name me. It didn't have to. The piece described, in soft cursive font, a long-time adjacent landowner whose continued refusal to engage with community standards has created uncertainty about the future of our beloved Marsh-Wren Point. It urged residents to support board efforts to clarify boundary obligations. It included a photograph of the salt marsh between my dock and the HOA's eastern gate that had been cropped to make the marsh look like it might be diseased. Effie Maitland from the deeds office mailed me a copy with a sticky note that read, "Be careful, this is escalating." 2 days later, a woman named Henrietta Pellicour knocked on my front door at 6 in the evening. Henrietta was 78, white hair, pearl earrings, a small dachshund on a leather leash. She had been a resident of Marsh Wren Point from 1991 to 2022. She had sold her home and moved to a townhouse in Port Royal because, she said, Margot Seeley had made her life unbearable over a butterfly garden. She brought me a pound cake and a manila folder. She sat at my kitchen island with my mother. She drank a glass of sweet tea. She told me everything. She told me Margot had been telling residents for years that the Caraway family had lost interest in the ground lease. She told me Margot had been billing residents for ground rent contributions of $150 per month per household, far more than any single resident's share of the actual rent. She told me that the HOA's printed dues schedule, which she had kept copies of going back to 2019, showed that the ground rent line item alone had been collecting $247,000 per year from residents, when the actual rent owed to my family was only $54,000. She handed me the folder. 6 years of HOA dues schedules, 6 years of newsletter statements, 6 years of ground rent contribution line items. The math was clean. The HOA had been collecting roughly $193,000 per year more from its own residents than it owed my family. Over 6 years, that was $1.16 million in over-collected ground rent. The HOA's checking account did not contain that money. None of it had been distributed back to residents. I asked Henrietta where the money had gone. She looked at me with eyes the color of pewter. She said, "Mr. Caraway, I would start by asking Mrs. Seeley about her cottage on Defusky. Defusky Island is a short ferry ride from Hilton Head. It does not have a public road system. It is a place where wealthy retirees keep 10,000 square foot vacation homes serviced by golf carts. Property values on the south end of the island start at $1.8 million and go up from there. The Seeleys had purchased a 4-bedroom cottage on Defusky's south shore in 2021 for $2.3 million in cash. Thatcher Seeley's brokerage had not closed a single transaction that quarter. I thanked Henrietta. I walked her to her car. She squeezed my hand at the door. She said, "Mr. Caraway, there are 30 of us. We're tired." That night, my mother sat at the kitchen table with her Sunday crossword and asked me one question. "Easton, what does an honest man do with $1.16 million of stolen rent money?" I thought about it for a long time. "Mama, he returns it to the people it was stolen from, and then he does it in a way that ends the woman who stole it." She nodded. She wrote "return" in 19 down without looking at the clue. I called my sister at 6 the next morning. I told her what Henrietta had brought me. Beulah was quiet for 9 full seconds. She said, "Easton, I'll bring everything I can pull from the courthouse by Tuesday. You start drafting the reversion notice. We're filing this Friday." I told her yes. I went out to the dock at first light. The tide was coming in. A great blue heron stood on the corner of the marsh, in the kind of stillness only herons can hold. I watched him for a long minute. Then I walked back to my study and started writing. Beulah arrived Tuesday morning with 2 banker's boxes, a thermos, and the look of a woman who had not slept well. She set the boxes on the kitchen table beside my mother's morning coffee. "Easton, I pulled everything Effie could pull without raising flags. Sit down." We spent 5 hours that afternoon walking the boxes, one document at a time. The Marsh Wren Point HOA had collected ground rent contributions from its 138 households at a posted rate that escalated from $125 per month in 2019 to $187 per month in 2024. The total collected, year by year, ranged from $207,000 in 2019 to $310,000 in 2024. The total collected over 6 years was $1,061,000. Of that, $54,000 had been paid to my family in 2019 through 2023. Only $20,000 had been paid in 2024 before payments stopped entirely. That left a difference of $793,000 in over-collected rent that had never been distributed to residents and had never reached the Caraway family. Beulah pulled a second folder. The HOA's checking account at South State Bank had a current balance of $41,000. The missing $752,000 had been moved out of the HOA's account in 86 separate transfers between 2019 and 2024. The transfers went to a single Delaware LLC called Marsh Wren Stewardship Holdings. The registered agent of Marsh Wren Stewardship Holdings was Margot Seeley. Marsh Wren Stewardship Holdings had purchased the Defusky cottage in 2021 for $2.3 million in cash. It had purchased a second property, a 6-bedroom on Fripp Island, in 2023 for $1.4 million. It owned a 2022 Audi Q8 and a 2024 Audi A6. Thatcher Seeley's brokerage had not closed any transaction with a commission over $15,000 since 2019. The math was clean. The Seeleys had been running a slow extraction operation against their own neighbors for 6 years, laundering the over-collected rent through a Delaware LLC and using the proceeds to buy themselves vacation property on barrier islands, 20 minutes from the development they were robbing. Beulah pulled one final document. It was a tax assessment notice for the Defusky cottage. The notice was addressed to Marsh Wren Stewardship Holdings, care of Margot R. Seeley, Marsh Wren Point HOA Office, 4 Live Oak Boulevard, Bluffton, SC. The HOA's office was the registered mailing address for the shell company that owned the stolen Defusky cottage. The Seeleys had not bothered to hide the connection. They had not believed anyone would ever look. I sat back at the table for a long minute. The afternoon light came in through the salt-streaked window of the porch and turned my mother's coffee cup the color of amber. My mother set down her crossword pencil. She said, "Easton, there are 138 families in that subdivision. Some of them are widows. Some of them are retired teachers like me. All of them have been paying a woman who has been using their money to buy beach houses." "Yes, ma'am." "Then I want you to do this properly. I want every dollar back where it belongs. I want every house on the south end of Defusky sold and the money returned. And I want that woman ruined." She picked her pencil back up. She filled in 23 across. I picked up the phone and called Crawford Drayton. Crawford had been my law partner at Hayward Quintrell for 19 years. He had specialized in commercial litigation. He had retired the same year I did. He owed me precisely one favor for a case I'd quietly carried for him in 2019. He answered on the second ring. He listened for 41 minutes. When I finished, he said one sentence. "Easton, tell me when to be at the deeds office. I'll bring the filings." Crawford Drayton drove down from Charleston on Wednesday morning in a 2003 Lexus he had been driving since the year his daughter was born. He brought a leather briefcase, a thermos of black coffee, and the cleanest reversion notice I had ever read. 16 pages, single-spaced, citing 31 separate provisions of the 1987 ground lease, the South Carolina Property and Conveyances Code, and the Federal Fair Debt Collection Practices Act for the over-collection scheme. We spent the morning on the porch reviewing it line by line. By noon, we had a final draft. By 2, Beulah had walked it through Effie Maitland at the Beaufort County Register of Deeds for a confidential pre-recording review. Effie called Beulah at 3:45. "It's clean. Bring it Friday at 4:30. I'll record it before closing." That afternoon, I called Maeve Cunningham at the Beaufort County Solicitor's office. Maeve had been an assistant solicitor for 19 years and had been elected solicitor in 2022. She remembered me from a probate case in 2014. I told her everything. She asked me to send Crawford's documentation by overnight courier. She asked me to send the HOA dues schedules. She asked me to send the Marsh Wren Stewardship Holdings filings. She said one sentence. "Easton, I have been looking for a case like this for 3 years. South Carolina HO has been operating under a soft enforcement regime for a generation. I'd like to make this one the example." She agreed to coordinate with Detective Quill Mahaffey at the Beaufort County Sheriff's Office White-Collar Crimes Desk. Quill had been working financial fraud in the county for 16 years. He had wanted a clean HOA embezzlement case for 9 of those years and had never gotten one because the HOAs always paid quiet settlements before any indictment. On Thursday, a man named Lemuel Cobb called me. Lemuel was 62. He had been a Marsh Wren Point HOA board member for the last 3 years. He was a retired civil engineer from Detroit who had moved to Bluffton in 2018. He had grown increasingly uncomfortable with Margot's budget presentations over the previous year. He had heard from Henrietta Pellicour that I was building a case. He told me, on a recorded phone line with his consent, that the HOA's last 3 monthly board meetings had included a ground rent reserve line item with no documentation of where the money went. He told me Margot had told the board the funds were earmarked for litigation against the Caraway estate and that the residents should trust the process. He told me he could provide every board meeting minute from the previous 3 years. He emailed them by midnight. I asked him one question. "Mr. Cobb, are you willing to testify?" He said, "Mr. Caraway, I worked 38 years at Ford Motor Company. I have audited the books of plants that built 500,000 cars a year. I have not seen something this dirty since 1997. I will testify under oath, in writing, on television, or on the moon." I thanked him. Friday morning, Crawford and Beulah and I drove to the Beaufort County Register of Deeds at 4:15. Effie Maitland processed the reversion notice in 18 minutes. The clerk's stamp went on at 4:48. At 4:48 on the afternoon of October 24th of 2025, every road, sidewalk, common area, recreational facility, clubhouse, dock, gatehouse, and 43 acres of common land within Marsh Wren Point HOA legally reverted to ownership by Easton Caraway under paragraph 31 of the original 1987 ground lease. The individual residential lots were not affected. The 138 homeowners retained fee-simple title to their own homes, but every other inch of the development was, as of that Friday afternoon, mine. We drove back to the Caraway place. We sat on the porch. Beulah brought out a bottle of Buffalo Trace my father had been saving since 1987. We poured 3 small glasses. My mother joined us. She did not normally drink. She drank that night. She raised her glass. She said, "To Pinckney, and to a man who would have loved this Friday afternoon." We touched glasses. The sun went down behind the live oaks. The marsh smelled like pluff mud and salt. I had one more thing to do. The Marsh Wren Point HOA had an emergency board meeting scheduled for 6 p.m. the following Monday. Margot had called it 3 weeks earlier to address the Caraway nuisance issue. I would be attending. She did not know that yet. Over the weekend before the Monday meeting, Margot Seeley made 4 serious mistakes. The first came on Saturday at 9:30 in the morning, when she filed an emergency injunction in Beaufort County Court of Common Pleas, seeking to halt any unauthorized property transfer activity by the Caraway family. The filing did not name a specific transfer. It did not allege specific harm. It alleged, in a vague, panicked sentence, that the Caraways were engaged in coordinated efforts to disrupt long-standing community governance arrangements. The motion was set for a hearing on Tuesday morning, the day after the HOA emergency meeting. The court would never hear it. Crawford filed a motion to dismiss on jurisdictional grounds Saturday afternoon. The judge, Bryant Whitmire, who had played golf with my father for 30 years, set the dismissal for 9 a.m. Tuesday and granted Crawford's request for emergency sanctions consideration against the HOA's attorney for filing without factual basis. The second mistake came on Saturday afternoon, when Margot called the Beaufort County Sheriff's Office a second time and reported that I had been engaging in intimidating drive-by surveillance of the Marsh Wren Point entrance. A different deputy this time, a young woman named Hayes Whitlow, responded to the call. She drove out to my gate. She read the original report from Deputy Trippett. She drove back to the HOA office and informed Margot in writing that no further police response would be provided to the community unless a specific, articulable criminal threat was alleged. She returned to the station and added a note to the running incident file. The note read, "Complainant continues to misuse 911 as a civil enforcement mechanism. Recommend administrative review of HOA dispatcher account." The third mistake came on Sunday morning, when Thatcher Seeley parked his white Lexus in front of my sister Beulah's gardening shed in Port Royal. He sat in the car for 15 minutes. He did not get out. He did not drive away. He just sat. Beulah was in her shed, potting a row of camellia cuttings. She did not look at the window. She did not call anyone. She finished her cuttings. She washed her hands. She walked into her kitchen. She picked up the rotary phone her late husband had refused to replace in 1998. She called Sheriff Pinckney directly, at the home number she had not used in 11 years. He picked up on the second ring. "Beulah, Pinckney, Margot Seeley's husband is sitting in front of my house in his car. I'll send a car." "No, send the car to Margot's house. The husband doesn't matter. Get the woman." Pinckney was quiet for 2 seconds. He said, "Tomorrow." He hung up. Thatcher Seeley drove away 17 minutes later. He did not come back. The fourth mistake came on Sunday evening at the HOA's pre-meeting reception, which Margot had organized at the clubhouse to rally board support for the Tuesday hearing she did not yet know would never happen. She gave a 20-minute speech to the 7 board members and 12 supportive residents who had shown up. She told them she had evidence that the Caraway lease was procedurally invalid. She told them that the family had abandoned their interest in the property, and that the HOA had a moral and legal right to assert fee-simple ownership of the underlying land. She told them she was working with trusted advisors on a permanent solution. Lemuel Cobb sat in the third row. He was wearing a navy blazer and a striped tie. He had a small digital recorder in his breast pocket. His attorney had reviewed his consent forms. He recorded 43 minutes of Margot's speech. He emailed the audio file to my attorney at 10:15 that night. Crawford forwarded it to Detective Quill Mahaffey at 10:22. Quill listened to it during his morning coffee on Monday at the white-collar crimes desk in Beaufort. He called Maeve Cunningham at the solicitor's office at 6:57. He said, "Maeve, she just put intent on tape. Let's pick her up at the meeting." Maeve said yes. I drove into Bluffton that Monday afternoon with Crawford and Beulah. We sat at a small breakfast spot on Calhoun Street that served the best shrimp and grits in the county. We did not talk about the meeting. We talked about Beulah's camellias. We talked about my mother's crossword. We talked about a lieutenant my father had served with in 1958, who had once stolen a watermelon from a senator. At 5:45, we drove to the Marsh Wren Point Clubhouse. The Marsh Wren Point Clubhouse was full at 5:55. 87 residents had shown up. Most were sitting in folding chairs on the main floor. 20-some more stood along the back wall. Henrietta Pellicourt, no longer a resident, but a guest invited by Lemuel Cobb, sat in the second row with her dachshund on her lap. Lemuel sat 3 rows behind her in his navy blazer. Margot Seeley stood at the front of the room in a cream silk blouse and pearl earrings and a wide leather Hermes belt that I could see through the clubhouse window from across the parking lot. She was practicing what looked like the first 3 lines of her opening speech. Detective Quill Mahaffey and 2 plainclothes officers from the Beaufort County Sheriff's Office White-Collar Crimes Unit were parked in an unmarked Tahoe at the southwest corner of the lot. They had a marked patrol car staged half a block down the road, behind a row of palmettos. Maeve Cunningham, in a charcoal pantsuit, was sitting in a Honda CR-V 2 cars down from the Tahoe, with the arrest warrant for Margot Seeley on the passenger seat, and the second arrest warrant for Thatcher Seeley on top of it. Crawford Drayton sat in the back of my sister Beulah's Toyota Camry, beside me, holding the certified recorded copy of the reversion deed in a leather portfolio. The stamped copy showed the Register of Deeds timestamp of 4:48 on the previous Friday. At 5:59, I opened the car door. I walked across the parking lot in a blue Oxford shirt, khakis, and a pair of leather loafers my father had bought me in 1989 for my law school graduation. Crawford walked behind me. Beulah walked beside me. None of us said anything. The double doors of the clubhouse opened onto a small foyer with a pineapple-shaped table lamp and a framed photograph of the original Marsh Wren Point groundbreaking from 1988. My father stood in the photograph beside the developer, both of them young and grinning at the camera. I touched the corner of the frame as I walked past. The clubhouse main room went still as the 3 of us walked in. Margot saw me first. Her face did the thing faces do when the brain has not yet given the rest of the body new instructions. She looked at Crawford. She looked at the portfolio. She looked at Beulah. She looked at me. She tried to speak. "Mr. Carraway, this is a closed board meeting. You are not authorized to..." "Mrs. Seeley, good evening." I walked to the front of the room. Crawford walked beside me. Beulah took a folding chair on the far end of the second row beside Henrietta Pellicourt. I turned to face the 87 residents. I held up the certified copy of the recorded reversion deed. I cleared my throat. I said one sentence to the room. "Ladies and gentlemen, at 4:48 on the afternoon of Friday, October 24th of 2025, I became the new legal owner of every road, sidewalk, common area, clubhouse, gatehouse, recreational facility, and 43 acres of common land within Marsh Wren Point." The room went quieter than I had ever heard a room go. Margot Seeley took one step backward. A woman in the third row whispered, "What?" I held up the deed. I let the room read the date stamp on the bottom. Then I held up a second document. Crawford's sworn affidavit summarizing the HOA's 6-year over-collection scheme, with the line item dollar amounts for each year and the total of $793,000 in stolen rent that had been laundered through Marsh Wren Stewardship Holdings into a Defusky cottage and a Fripp Island house. I let the room read that, too. A man in the 5th row said, very quietly, "Oh, Lord." The clubhouse doors opened behind me. Detective Quill Mahaffey walked in with 2 officers and Maeve Cunningham. Margot looked at them. She looked at me. She looked at the deed in my hand. She said one sentence, and it was the smallest sentence I had ever heard her say. "This is a misunderstanding." Maeve Cunningham stepped forward. She held up the arrest warrant. Margot Rebecca Seeley, you are under arrest for embezzlement under South Carolina Code 16-13-240, conspiracy to defraud under 16-17-10, theft by deception, money laundering, and 7 counts of fraudulent practices in the operation of a community association. Hands behind your back. The handcuffs went on at 6:11. Margot Seeley did not resist. She did not speak. She did not look at the room. She looked at her own feet as Detective Mahaffey walked her between the folding chairs toward the foyer. Henrietta Pellicore did not move from her seat as Margot passed. She held her dachshund. She watched. At the same minute, a second Beaufort County Sheriff's Office unit pulled up to the Seeley's Defusky ferry dock and intercepted Thatcher Seeley as he tried to board the 7:15 ferry to the island with a Hartman roller bag and a manila envelope. He was placed in handcuffs at 6:14 on charges of conspiracy, money laundering, and obstruction. The roller bag contained $18,000 in cash and the deeds to the Defusky and Fripp Island properties. The Seeleys did not get to go home that night. 87 Marsh Wren Point residents watched the front doors of the clubhouse close behind Margot. I stood at the front of the room beside Crawford and waited for the silence to settle. I looked at them. I held up the recorded reversion deed one more time. I said, I am Easton Caraway. My great-grandfather Roderick bought the parcel that became Marsh Wren Point in 1879. My father, Pinckney Caraway, leased 60 acres of that parcel to the original developer in 1987 for the purpose of building this community. For 31 years, every one of you paid your dues honestly, and every dime of the ground rent reached my family without incident. Beginning in 2019, that changed. I let the room sit with it. I want to be clear about 3 things tonight. The first, I am not, as of Friday afternoon, your enemy. I am your landlord. I am, as of Friday afternoon, also the legal owner of every street you drive on, every gate you swipe into, every common area you walk through, and the clubhouse you are sitting in. The reversion clause that gave me this ownership activated on August 15th of this year, 2 months ago, when your former president had failed to pay my family for 12 consecutive months. I exercised the clause. The Register of Deeds recorded it Friday afternoon. The second, I will be funding the routine maintenance of all common areas. Landscaping, road repair, dock upkeep, clubhouse utilities, security. From the existing ground rent reserve, the amount you have been paying for ground rent contributions, average $187 per household per month, will be eliminated, effective immediately. Your monthly HOA dues will be reduced by approximately 80%. The man in the 5th row said, "Oh Lord," again, quieter this time. The third, the $793,000 that Mrs. Seeley collected from you and never gave to my family will be recovered through court-ordered restitution and returned to you. The Defusky property and the Fripp Island property will be sold by court receiver to fund the recovery. You will each receive a check by certified mail within approximately 90 days. The amount of each check will depend on how long you have been a resident. You may have questions. My attorney, Crawford Drayton, is going to remain in this clubhouse for the next 2 hours to answer them. I am happy to answer some myself, but I want you to know that the family that owned this land before any of us were born intends to continue owning it, and we intend to be a better neighbor than the woman who has been speaking for us for the last 7 years. There was a long, quiet moment. Then a woman in the 2nd row started clapping. The man in the 5th row joined her. By the time I walked back to take a folding chair beside Beulah, the entire clubhouse was on its feet. A WJWJ-TV news van pulled up outside at 6:38. The reporter, a woman in her 40s named Selah Pinckney, who happened to be my sister's husband's cousin, set up the camera in the parking lot. She filmed the last 20 minutes of the residents' applause through the open clubhouse windows. She got me on camera at 7 o'clock. She asked one question. Mr. Caraway, the HOA president was just arrested. You just announced you've taken ownership of the common areas. What would you say to the residents who paid those dues for 6 years and didn't know where the money was going? I thought about it for a long moment. I said, I would say their money is coming home. So is the land. Margot Seeley pleaded guilty in March. 5 years at the Camille Griffin Graham Correctional Institution outside Columbia. 3 before parole eligibility. Full restitution of $793,400. A permanent bar from serving on any homeowners association board or any nonprofit fiduciary position in the state of South Carolina for the rest of her natural life. Thatcher Seeley pleaded guilty in May to 9 counts of conspiracy, money laundering, and obstruction, 4 years federal, plus $620,000 in restitution. His brokerage license was revoked permanently by the South Carolina Real Estate Commission. Marsh Wren Stewardship Holdings was dissolved by court order. The DeFusky cottage sold at receiver's auction in June for $2.7 million. The Fripp Island house sold in July for $1.6 million. The total recovered was $4.8 million. The court distributed the restitution to the 138 Marsh Wren Point households by tenure. The longest tenured family received $19,000. The shortest, $2,000. The total return to residents was $793,400, plus interest, plus the additional civil damages negotiated by Crawford on behalf of the resident class. A reconstituted Marsh Wren Point HOA was formed in February under bylaws that Crawford and I drafted with Lemuel Cobb. The bylaws capped the total monthly dues at $38 per household, sufficient only for security, basic maintenance, and a modest reserve. The bylaws prohibit any board member from holding a financial interest in any LLC doing business with the HOA. The bylaws require an annual independent audit and a public quarterly financial statement posted in the clubhouse and mailed to every household. Henrietta Pellicore moved back to Marsh Wren Point in August. She bought a brick 3-bedroom on the lot directly beside her old one. She replanted her butterfly garden. The first monarch landed on her milkweed on a Tuesday afternoon in late September. She called me from her porch and made me listen. I converted 12 acres of the Caraway Tract, the salt marsh frontage along Battery Creek, into the Pinckney-Caraway Low Country Land Trust. The Land Trust holds the marsh in perpetual conservation easement and operates as a public access nature preserve managed in partnership with the South Carolina Department of Natural Resources. The trust runs a Saturday morning bird banding station with Audubon, South Carolina volunteers, and a summer educational program for Beaufort County public school students. My sister Beulah serves as the trust's first chair. I established the Lavinia Caraway Low Country English Scholarship at the College of Charleston in August. It funds first-generation South Carolina students pursuing degrees in English or education. The first scholar we funded was a young man named Otis Wesselby from Hampton County, whose mother is a CNA at a nursing home in Allendale. He started his freshman year in September. He wants to teach high school in his hometown. My mother attended the scholarship's first awards reception in a navy dress she had bought in 1979. She gave a short speech in which she diagrammed a sentence on a whiteboard for the audience. The audience clapped for nearly a minute. Last night, my mother and Beulah and Crawford and I drove down to a fish camp on the May River and ate fried flounder and hush puppies at a picnic table under the live oaks. The sun went down behind DeFusky. The marsh smelled like pluff mud and wood smoke. We drove home with the windows down. The Spanish moss was heavy with dew. A barred owl called from somewhere deep in the live oaks. I'm Easton Caraway. That was my great-grandfather's land. That was my father's lease. That was my sister's records. That was my mother's resolve. That was the deed I bought at 4:48 on a Friday afternoon.
Margaret Seeley didn't fall because Easton Caraway got angry. She fell because Easton Caraway read the paragraph everyone else skipped. For 7 years, she'd been running a quiet exaction operation against her own neighbors, dressing it up as community centers and using a sheriff's deputy as her tax collector. Not once in 7 years did anyone ask the basic question: who actually owns the land under Marsh Wren Point? And that's the lesson. A scheme survives on the assumption that nobody behind it had ever read the lease. Real strength is reading the lease, all 62 pages, including the paragraph the original drafter put in for the situation everyone said would never happen. Easton didn't beat her with anger. He beat her with paperwork. He kept the records. He called his sister. He filed the reversion. He let the deputy who showed up at his gate file the report that would become the first thread in a case that would unravel $1 million embezzlement. If you ever had an HOA decide they could invent dues to charge a non-mentor, drop the story in the comments. We hear each other. Hit subscribe. Next week, we head to upstate Vermont, where an HOA tried to redirect a 100-year-old maple sugaring operation. Turns out, the sugar marker was a Yale-trained botanist.